Hello and welcome to Partially Redacted, the podcast where we discuss privacy and security engineering and related topics. I'm your host, Sean Falconer, and today I'm joined by privacy and data protection writer Robert Bateman, and we'll be talking about how the privacy landscape is changing, the impact of recent privacy enforcements, and transatlantic data transfers. Robert, welcome to the show.
Thanks, Sean. Good to be here.
Awesome. Yes, thanks for being here. We have, I think, a lot to discuss on a pretty tricky topic, but before we dive in, let's start with the basics. Who are you? What's your background, work history? How did you end up where you are today?
Sure. So I am a writer focusing on data protection, privacy, some security, AI, other related topics. And well, I started to become interested in this field whilst I was working at a university. And my job was to kind of represent students that were in trouble against the university. They'd been accused of cheating, or they wanted to complain, or they'd been kicked out, and so on. And I started to do a law degree for free as I was working there, and really became fascinated by the topic of data protection and privacy. I had to do a research project, and at the time, the Data Protection Act, which kind of sits alongside the GDPR in the UK, was being debated in Parliament. And there was this, in the UK law, there's this thing called the immigration exemption, which basically lets the government off the hook for various data protection rights when it comes to maintaining effective immigration control. And so I did my project about that. It's a very bad, ugly piece of law. And actually just last week or the week before, it was overturned again in the courts here in the UK. So that was good news for me. And I started writing on the side of my main job about the GDPR, which was quite new at the time. And the companies I was writing for just wanted so much content on every aspect of the law. And I ended up getting to know it very, very well. So following that, I quit my sort of full-time job and started writing full-time. Created a bit of a niche in this field and became better known. Started writing some more kind of journalistic content for an American news site. Then I took on a full-time job, which allowed me to do even more of this stuff, and also running events about the subject. And I interviewed some very well-known people in the field in that job a couple of times. Max Schrems, for example, who we might discuss later, who many listeners may have heard of. Johnny Ryan, who's a well-known privacy campaigner here in Europe. I'd say over 100 privacy and data protection professionals, sitting on panels, doing interviews, and writing a lot of articles. I counted my articles on the topic of privacy and data protection the other day, and I've racked up about 1,500 over the years. So I'm back freelancing now, writing for privacy-focused companies, and there are a lot of them because this is such a burgeoning and fast-developing field, as you'll know, Sean.
Yeah, absolutely. I mean, that's really impressive. 1,500 articles in the field, and I like that you said that you focused on privacy, security, and AI. So all the easy, non-controversial topics are right in your wheelhouse.
Yeah. Some of my AI-related takes are more cynical than others. I probably won't be hired by any AI directly focused AI companies anytime soon. But there's a lot of interesting stuff going on, a lot of applications of AI in security in particular and privacy as well that are that I'm less cynical about, let's put it that way.
Mm-hmm. Yeah, well, I definitely want to eventually get into some of your thoughts around AI. Of course, it's a huge topic in everywhere right now. But before we get there, maybe we can start with just getting your thoughts on how privacy regulations have evolved over the years that you've been involved in the space, and what impact has that had for businesses?
So the GDPR was a really big deal that everyone made a lot of fanfare about at the time when it took effect in 2018. But it wasn't, I mean, it was different from what preceded it, but I don't think people appreciate how similar the previous law was, the Data Protection Directive in the EU. There were some changes for the GDPR, but a lot of the core principles were the same. And businesses in Europe have been doing this stuff for a long time. The most interesting developments, certainly this year, have been in the US, where there is a lot going on. You've got 5 new privacy laws taking effect this year. The FTC is getting very busy on regulation and enforcement. And you've got California's got its new agency for regulating privacy, the California Privacy Protection Agency. And around the world as well, things are developing. But because the US lacks, I think it stems really from the lack of a recognition of privacy directly or perhaps comprehensively in the Constitution, that the US doesn't have the same framework as many other countries. So it's kind of catching up a bit now with some very interesting kind of conflicting and piecemeal pieces of legislation. And I think that the consumer or individual awareness of privacy has grown. Data goes both ways, I find, when trying to figure out whether people care more or less about their privacy. I think that it's a difficult question, but obviously I think COVID had a big impact as well, because whereas we were living most of our lives online before, we were suddenly living almost all of our lives online at that point. And because of the business model of many of the most dominant companies online, that meant that a lot of data was being scooped up. So the legislation is developing worldwide and in Europe as well, and particularly in the US. And I think that business practices are changing, not necessarily in tandem with the regulation that's coming up, though.
Mm-hmm. So I want to dig in a little bit to something you talked a little bit about there, about the sort of differences when it comes to like personal privacy in the US versus maybe other parts of the world. So how do the cultural differences between, say, the US and EU impact their approach to privacy, and what sort of, you touched on this a little bit, but what impact has that had essentially to the regulations around privacy?
So the differences in the US and the European approaches to privacy have caused one of the biggest headaches in data protection compliance, as it were, to do with international data transfers, which I guess we'll discuss in a bit more detail later. I think essentially the US approaches privacy from a sort of consumer protection angle. The FTC uses its consumer protection powers to enforce on privacy occasionally. We've seen that recently in action against GoodRx, the drug
Right.
prescription drug app. And the EU approaches it from a more human rights angle. The UK is somewhere between the two, I think, but it still has the European legislative framework, and also has a strong tradition of privacy historically. It's kind of going the other way a bit now. But I think that difference in approaches manifests in a difficulty in doing business between Europe and the US. The laws in the US tend to have carve-outs for smaller businesses, which the GDPR basically doesn't. There is flexibility, but it doesn't really exempt anyone entirely. The US is also driven by litigation because the authorities, it lacks the same strength of public authority enforcement that we have in Europe. So businesses are more worried, I think, about class action lawsuits than about regulators. FTC is pretty powerful, though, but I think that's given it a slightly different emphasis in the US. And the US has very powerful intelligence services, and they have a lot of power both on paper with US laws that allow for access to people's data, and in practice where the intelligence services will sometimes, where they lack official power, they will find a way around that by purchasing data on the open market, for example. The same stuff happens in Europe, but on the whole, I think there is more restraint among intelligence services. Again, the UK is a bit of an exception here, where GCHQ, the main intelligence service, is pretty ubiquitous and powerful. But the US approach to intelligence gathering, I think partly because of the position of the US in the world and its foreign policy, I think that has a big bearing as well, and represents a bit of a difference between the US and Europe in this regard.
Do you think that part of the reason some companies like Meta, for example, have had trouble in Europe or consistently had challenges around GDPR in Europe has to do with some of these cultural differences, or do you think there's something else that's going on there?
So on the face of it, so I should probably give a bit of background into the issue here. So Meta, or Facebook as it was, has been taken to court a couple of times by Max Schrems, who I mentioned earlier, for transferring personal data from the EU to the US without appropriate safeguards under the law. Now, there used to be something called Privacy Shield. I don't, forgive me, listeners, if you know all this, but I'll give a bit of background, which allowed companies to, it was one of the ways that companies could legally do that, transfer data from Europe to the US. And the case against Meta took aim at this Privacy Shield framework, and the court found that it wasn't capable of protecting Europeans' personal data from the US intelligence services. So the issue here is that the US law allows a lot of what is considered in Europe to be quite intrusive surveillance practices by US intelligence services. And the GDPR says that you can't really allow personal data to be accessed by bodies like the NSA. And there's really no way to prevent that in theory if you're a company like Meta, who has its European arm and its US arm and does a lot of business in Europe and eats up a lot of personal data. So I think that the cultural aspects play into that because, firstly, the intelligence services in the US are very powerful, and they say, and perhaps, justifiably, that they need this power to keep Americans safe. They need to have pretty much free access to personal data. Of course, there are checks and balances in the US. It's not quite as bad as some people would like to imply, but there are weaknesses in the law from a European perspective. And Meta gets a lot of requests for access from the intelligence services and grants a lot of requests for access, hundreds of thousands a year, I think, both of Americans and non-Americans. So, yes, I think culturally, I've always wondered if, it suits the US government to have companies that collect so much data, because they're kind of, you can look at it as a bit of a proxy. You have the Stasi in East Germany hiding microphones in people's watering cans or whatever. We don't have to worry about the government really doing that anymore, because they have access to it via these other companies that are swallowing it up and storing it for them. And I don't think Meta is doing that nefariously in that sense. But we have a culture in the US where it is permitted because there aren't strong privacy laws that would stop Meta from doing that, and perhaps allowed because it serves to provide the intelligence community with a lot of data. So that's the cultural aspect. And I think that people probably justifiably accuse the EU of hypocrisy here, because European countries also have intelligence services, but the law is just constructed in such a way that is a problem legally, in compliance terms in particular.
Right. Yeah. You don't have to hide cameras and mics in people's houses if they're readily giving up that information essentially to a third-party application that they're using for entertainment purposes essentially. And then if that person or that company allows the government agency access to it, then it's essentially, like you said, a proxy to the data that they need. Is that the key concern around the regulations around transatlantic data transfers? Is essentially the government interference with the data?
Yeah, basically. So the idea is that in Europe there are two relevant fundamental rights here. It's not really a constitution, but it's basically, it's called the Charter of Fundamental Rights in the EU. And one of those rights is the right to privacy, and another is the right to data protection. And if you're going to operate in Europe, those rights are kind of inalienable. They're not absolute, but the idea is that the GDPR should protect people and their fundamental rights, regardless of where the company that collects their data is operating. So in the US, the main problem is to do with the right to redress, or the right to appeal. So intelligence services can basically surveil people outside the US, and there's not very much that non-Americans can do about it. There's not a great deal that Americans can do about it either, but the relevant situation is for non-Americans. So the Europeans and the Americans are trying to solve this with a new version of the Privacy Shields framework that I mentioned earlier. But the right to redress is a big problem. That's another thing under the Charter, by the way. If you are accused of a crime, or if you have your fundamental rights interfered with, you should have the right to challenge that. And that right doesn't exist in the US as it would need to satisfy European standards.
When companies run into problems with something like the transatlantic data transfers or some other type of violation of GDPR, how enforceable are those fines? Do companies actually end up paying them?
It's really hard to say, and I have looked for this because it's a very interesting question. Because the reason it comes up is, well, the reason it came up for me recently was Clearview AI, who you've probably heard of, is a New York-based company that basically has this big database of people's facial images and a big biometric database that identifies them, and it sells access to its database to the police. And this is not really acceptable under the GDPR. So I think 4 or 5 regulators have fined Clearview. 20 million euros for most of them. I think 7.5 here in the UK, pounds that is. But Clearview keeps saying, well, we don't operate in Europe, so it's nothing to do with us. Why are you even talking to us? Effectively, they do go through the motions and they are appealing, I think, and they have operated in Europe. But the question becomes, well, what are these regulators going to do about it if they're not interested in, if it's a company like Google doesn't want to lose its European market, it would much rather pay a fine than be ejected from Europe altogether. If it's a company that claims it doesn't operate in Europe at all, then who cares? They can just not pay. So that is an issue. I don't know if it's ever going to be solved, really, for international companies. For regular European companies, yeah, I think they normally pay. There was the Irish Data Protection Authority reports on this, and the latest report, they collected 17 to 20 million euros, something like that. They said that's actually been collected and gone to their treasury. But I think the problem lies where it's a non-EU company that can just say, well, we're not paying. I don't think it's come up yet that a company's actually been kind of blocked from Europe. There was this OpenAI thing, but that's been slightly misreported, I think. But I would imagine that the fines collected are less than the cost of enforcement. I think most. I mean, the biggest fine in this area is still the FTC, who fined Facebook $5 billion over Cambridge Analytica a few years ago. We've had nothing approaching that in the EU. I think the largest is against Amazon for 790 million euros, I think. And I mean, Amazon are going to be appealing that for a long time. So we'll see what actually they end up paying.
Sorry for the interruption, folks, but I just had a few quick reminders. If you're enjoying this episode, please hit the subscribe button so you can always get the latest episode. And help others discover the show by leaving a rating and review in your favorite podcast app. It really helps. Last thing, before I get you back to the interview, if you are interested in the topics discussed in this podcast, then you should definitely join the Partially Redacted community at skyflow.com/community. There, you can meet other interesting and like-minded individuals like yourself, share your expertise, or just passively engage, totally up to you. All right, now back to the show. Right. And then for companies that, have the best intentions in mind, like how do organizations go about ensuring like compliance with privacy laws when actually transferring data between, say, the US and EU?
Yeah, I mean, that is the hardest area, the transfers. You can comply with everything. Some people say it's impossible. I don't really agree with that. I think it's impossible for some business models. But the transfers are really the sticking point at the moment, because if you want to be able to see the data in the US, then that means the NSA or whoever can also see it if they ask for it. And this is the difficulty. If you're transferring personal data that's encrypted, for example, and the US company can't decrypt it, then that's okay, because the encrypted data without an encryption key, there's a low enough risk there. But it is really, it's a really tricky point. And this is one of the reasons I'm quite glad I don't have to actually advise on this stuff. I just get to write about it in the abstract, because I don't think people quite realize how hard it is to be totally in compliance with that part of the law at the moment. There is a new possible solution coming down the track in a few months with this new agreement. When it comes to data transfers, though, I mean, there are a few things you can do in theory. It depends what you want to do with the data, really. Like I say, encryption, whereby you don't have the key as the importing party based outside of Europe, that's an option. That doesn't work if you want to actually do anything with the data, of course. But if you can hand the key over to a third party based in Europe, then that's possibly an option for data transfers. Location of the servers matters up to a point. If you want to locate your infrastructure in mainland Europe, that's helpful to some degree. But because of the way US law operates, the intelligence services don't actually care where the data physically is. They just care about whether or not you can access it as a US company. So locating your data center in Europe is one piece of the puzzle, I think. It gets very complicated and technical in the nitty-gritty about what constitutes a transfer and what doesn't. But you can think about any measures you can take, technical measures, to ensure that you can't see the data and the NSA can't access it. I would love to be able to say that, just think about the risk that the NSA will want the data you have. Think about the sensitivity of the data and all those factors. Unfortunately, unfortunately for American companies, the EU's regulators say that is not to be taken into account. If there's any risk, or if the NSA is kind of legally capable of accessing personal data, then that's a problem, even if the chances are very, very low. This is why Google Analytics is having issues. Google says, we've never been asked for data from analytics. The intelligence services don't really want that. And I can't imagine they do. I mean, they can just ask for Gmail data or whatever. But still, this part of the GDPR doesn't refer to risk. It speaks in absolute terms about data transfers. You either the foreign intelligence services can access data or they can't. And if they can, then that's a problem. So it's very disheartening, actually, to discuss compliance in terms of transfers, because that's the really difficult bit right now. In terms of the other stuff, I mean, that's all great. It all ties in quite nicely with customer trust and, building a sustainable business model that doesn't depend on doing illegal stuff. The principles of data protection under the GDPR are all very admirable things. Don't collect data you don't need. Don't store it longer than you have to. Apply reasonable security measures. That stuff's all very much doable. The transfers part is the real sticking point at the moment. Could be solved soon, though.
Yeah. So, I mean, what you described there about even a company that has good intentions, it sounds like it's very difficult to get right, or it may be even impossible, or it's not very clear how you would do this even if you wanted to. So you kind of alluded to this, but how do we basically, for EU US data transfers, like how do we make progress in this area? What effort is going into trying to fix or address this problem?
I think fundamentally there will have to be, if it's ever going to be permanently solved, there will have to be a reappraisal of fundamental constitutional, even law, either in Europe or in the US. because those two regimes are just not compatible. Either the US needs to give more rights to people who are subject to surveillance, or Europe needs to give fewer rights to those people, because there are two competing regimes there. Now, to get away from the philosophizing, in a couple of months, this new agreement between the US and the EU should pass. It's called the EU-US Data Privacy Framework, and it's designed it's like a self-certification scheme. So US companies can sign up, and they promise to implement European-style protections over the data that they have. The US intelligence services promise not to spy too hard, and also the US is setting up what it calls a data protection review court. We'll see if the European courts agree that it's a court, but that is an attempt to solve the right to redress issue that's plagued these agreements. This will be the third attempt. The other two have been brought down by Max Schrems. Now, he is going to challenge this one. He's told me that personally, and he's told many, he's made no secret of it. So we'll see if he succeeds. I think that it's the European Court of Justice that looks at these previous agreements. I think they are liable to make the same decision again, which will mean that this third agreement fails too. But that probably won't be for another few years, so there might be a bit of respite. I should say as well, I mean, you're asking me about pure sort of legal compliance questions. There are billions of technically unlawful data transfers going on every day. I mean, there's one happening right now as we record this, I imagine, because that's just how it works. And, life and the economy keeps running. So there is a sense in which all this stuff is a bit abstract anyway, but it's still not really sustainable to have the law broken so many billions of times a day by so many thousands of companies. I mean, it says something about the law, and it's not a sustainable situation. So hopefully we'll get a bit of respite in a few months. I mean, I say hopefully. I'm agnostic on whether the agreement is any good, but it will mean that it is possible to be compliant at least.
Mm-hmm. Yeah, so you called out that there's basically billions of these sort of infractions going on time, including one right now as we record this. So if we take something like a company like Meta, whose business model depends on user collection, if someone was actually building Meta from scratch today, knowing what we know about GDPR, Europe's stance on data transfers, could someone build Meta from scratch today such that it is in compliance, or is a business like that something that just can't exist under European privacy laws?
So I really like this question. I'll get transfers out of the way first, because there might be an answer there. I mean, if Meta were to restructure itself in such a way that its European entity was completely independent from its US entity, it might be possible. And also it segregated all its European data in Europe and all its American data in the US. That I'm pretty sure that doesn't happen now. I mean, the data governance within Meta apparently is a bit of a nightmare. So transferring personal data is a bit of a euphemism, really, because all the data is just sloshing around. It's a transfer is kind of a legal term rather than a technical one. But it's possible that with enough corporate restructuring, they might be able to solve the transfers problem. If we put that to one side and focus on the other stuff, the biggest problem for Meta at the moment, other than the transfers, is their lawful basis for targeted advertising. Now, on the day of the GDPR took effect, they changed the way that they justified ad targeting, because obviously targeting ads requires a lot of personal data. They previously said they did it with people's consent. Then the GDPR strengthened the definition of consent a bit, and they thought, is this going to work? Is this still going to be legal? So in 2018, they started saying that they were providing targeted ads under a contract with their users, as though the users kind of signed up for that, and they were just obliging. Now, this is problematic, and over the last 5 years, they've been battling with the EU's regulators to continue doing this, and they were told not to recently. So they can no longer say that targeting ads is part of their terms. I suppose the reason I mention this is because Meta could get consent for this stuff, and then it would pretty much be fine. Consent is not the only way to do things under the GDPR, but it is considered appropriate for stuff like targeting ads. Now, whether Meta could survive as a business if it had to do that is kind of another question, because lots of people would say no, and then they would say that their ads would be less effective. But in legal terms, I mean, it's possible to have a social media platform with ad targeting in the EU under the GDPR. You could do a lot of what Meta does. You just have to ask people. And I think that consent would probably solve a lot of their problems.
Right. So a lot of it is potentially a matter of being transparent about what you're doing, and it could potentially impact like your overall revenue rather than opting someone in automatically versus asking for consent. But you could do it in essentially a legal way.
Yeah, I mean, people like to downplay consent under the GDPR because there's a bit of a myth that you need consent for everything, which is not true. It's just one option out of 6 under the GDPR. So it's kind of less important than under some other privacy laws or data protection laws. But for stuff that's considered a nice to have, like the ability to profile people and sell their profiles to advertisers and that kind of thing, consent is probably the best legal basis for a company like Meta to do stuff like that. And that is a big legal problem for them at the moment.
Mm-hmm. So before we wrap up, I did want, and we probably can't do this justice. We probably need to do a whole episode on it, but I do want to get your thoughts on essentially the impact of generative AI and what that might have on privacy. Obviously, this is a huge topic now with the explosion of ChatGPT, and there's a huge investment from startups now developing all kinds of technology around the generative AI landscape. So I'm curious to hear your thoughts on this in terms of potential impact from a privacy perspective.
So this is going to be another data transfers type issue, I think, in the coming years, because so in Europe we separate. I mean, colloquially we can say privacy for everything, but privacy and data protection are technically 2 different concepts. And OpenAI, if we take them as the example, and ChatGPT, just the most obvious example of an AI application that everyone's talking about. Privacy-wise, it's not so bad. It's all, if we accept that it's all publicly available data, if we grant them that, then there are still privacy issues, but it's mostly data that people have put on the internet, and it's not great for it to be used in other contexts, but it's not confidential information on the whole. So the bigger problem is data protection for a company like OpenAI, because that data they're using was not provided for the purpose of training an AI system. And people have rights over their personal data. So any personal data of yours or mine in that training set, we don't have a model of data ownership here in Europe, but you should have some degree of control over that data, and you should be able to find out what they've got. You should be able to ask them to delete it. You should be able to object to their use of it in certain ways. I think all of that is pretty much impossible with a large language model. And this has been an issue for OpenAI in Italy, where the Italian regulator has said you don't have a legal basis, or you don't appear to have a legal basis for processing this data. Now, that's just the training set. I mean, OpenAI didn't collect that themselves. It comes from Common Crawl, which is a non-profit that just kind of scrapes data from the internet and makes it available to companies. But they're still responsible for how they use it. And I don't know if it can be used in a way that complies with the GDPR. So I think that is a fundamental problem for large language models in particular, image generation AI as well, that there's inevitably going to be, if you've got that much data, then there's inevitably going to be personal data in there, and you need a legal basis for using it. You also need to tell people what you're doing with their data, or have a good reason not to. And it's possible that you could make an AI system that complies with all those principles, but you'd better think about it beforehand. And I'm not confident that a lot of these AI companies have done that. So that's just one aspect. There's also the actual product itself. So if we take ChatGPT as the example again, it comes out with a lot of wrong stuff about people. Now, this is a good example of why it's more of a data protection issue than a privacy issue, because under data protection law, you've got a right to accuracy. So personal data has to be accurate. And if you maintain or process inaccurate data about someone, then you have to let them correct it. And you have to, well, just generally make sure that you're not putting out falsehoods about people. So that's another issue. And that was mentioned by the Italian regulator too. So there are all sorts of compliance issues, and Europe's going to find itself with real difficulty, I think, because most of this stuff is governed by the GDPR, not everything. And the GDPR it's got stuff about automated decision making in it, which can be done by AI, but it's not an AI specific law. And they are working on one, but the EU is rather slow. So it might be a while before that passes. I think that data protection authorities are going to have real difficulty enforcing the GDPR against these companies. People might not want them to, because, I mean, it would just mean you can't operate. There are unanswered questions as well about whether an algorithm is personal data, if it can produce personal data about you. That's a really tricky question, I think. Should you have access to model weights and biases and all that kind of stuff? So it's going to be an interesting few years, and it's another area where regulation is slightly behind the real world, I think.
Yeah, there's a lot of, I think, complex issues here. I mean, we recently did a show on data deletion, and data deletion is a hard problem without it being wrapped up in one of these large language models. I can't even imagine how complicated it would be to try to, unwrap that black box to figure out, where what parts of the model or what parts of the information needs to be removed or retrained or something like that. And I think you raise a good point about the sort of like tendency for, at least in the chat GPT world, of it to hallucinate certain facts. I've done, like lots of people, done the query of, who is Sean Faulkner, I would say 10 to 15% was accurate, and the rest of it was mostly made up. Apparently, I'd founded some companies I'd never actually heard of, and had a few jobs that I didn't actually have in the past. So, yeah, I think that is there's a lot to think through, and it's moving so fast. Clearly, like the legalities around it are not going to be able to move at the same speed as the innovation that's happening in the industry right now.
Yeah. And I mean, just one more thing on that. The Italian regulator said a lot of stuff about not wanting to hamper AI development or, quash innovation in some way. But if you applied all the rules to a company like OpenAI, I mean, they just wouldn't be able to continue operating in Europe. It's getting that balance, I think, between allowing this kind of activity if they want to allow it, and making sure that the law isn't just totally disregarded, which is a risk in itself, I think, if you have what's essentially a human rights law and you just allow companies to ignore it. I mean, there's this kind of societal level risk there, I think. So the existing law does cater for a lot of AI related stuff, but I think it's either a blunt instrument in some areas or just doesn't have the right language or gets the balance wrong. And it's going to be very difficult to develop new rules in time, I think, particularly in the US, I must say, where they're a long way off regulating this kind of stuff.
Yeah, I mean, clearly we want to make sure that companies are doing the right things to protect people's data, but we also don't want to restrict companies so much that essentially our consumers or people in the world can't take advantage of some of this innovation that's going on, because there is real value there from whether it's in the sort of generative AI of speeding up whatever it is that you do. Maybe it's writing or coding or whatever you're using it for. So Robert, I want to thank you so much for being here. I really enjoyed this conversation. I think uh, I probably need to listen to this back a couple times with the amount of stuff that we covered. I think there's just so much complexity around the ins and outs of particularly like the transatlantic data transfers, and how do you think through that. It's a difficult thing for any company to navigate. So I appreciate you coming on here and explaining and sharing your expertise.
That's my pleasure. I hope I haven't presented too gloomy a picture of the compliance landscape. The transfer stuff is a problem unto itself, and the getting privacy and data protection right is doable if we put the kind of legal rabbit holes to one side, applying those principles and respecting people's rights and being transparent. These are all really doable things. I think companies that implement these principles and rules early, in particular, have a real advantage as the world's attitude towards privacy changes. Getting it right now before the US introduces even more laws on this is really important.
Yeah, I think that's well said. I think that's a great place to leave it. I think it's very important for all companies, and this has come up multiple times on this podcast, of course, talking to all these privacy and security experts. You need to be thinking about this from day one. It's going to be a lot more difficult to deal with down the road if you've built all these. I mean, look at the like our discussion around Meta. It's something that's going to be really really hard to unravel once you've built all these systems and you haven't even thought about this.
Yeah, the world is changing a lot, and the US in particular is changing a lot, and it's really time to start implementing those privacy-focused principles and controls as early as you can in the production and development process, I think.
Awesome. Thanks again, and cheers.
Thanks so much, Sean. Good to talk to you.